Good afternoon. I'll turn straight to an update on several of the tribunal's ongoing trials. In the trial of Milan and Sredoje Lukić, Judge Gűney announced at this Monday States Conference the Chamber's intention to render its appeal judgment before this year's summer recess, which will start on 23rd of July. Also on Monday, the defense in the case of Zdravko Tolimir began. Tolimir, who is representing himself, will be calling a total of 4 witnesses and will use 36 hours for his examination in chief. The Chamber is currently hearing the testimony of the first defense witness, Slavko Kralj, who was an officer in the Department for Liaison with Foreign Military Representatives in the main staff of the Army of Republika Srpska during the period relevant to the indictment. And the proceedings in this trial, as well as the trials of Radovan Karadžić, Jovica, Stanišić and Franko Simatović, continue this week and next as scheduled. In the trial of Radovan Karadžić, the Chamber is currently hearing the testimony of Tomas Blažić, an investigator for the Office of the Prosecutor, who is testifying about the film on events in Srebrenica made by Zoran Petrović Piročanac. In the trial of Jovica, Stanišić and Franko Simatović, the Chamber is currently hearing the testimony of Borislav Pelević, a former Serbian volunteer guard member. And next, a reminder that the States Conference in the trial of Ante Gotovina and Mladen Markač will be held this Thursday, the 26th of January at 3:30 in courtroom 3. And in the case of Vojislav Šešelj, an administrative hearing has been called for the 7th of February at 2:30 in courtroom 3 to discuss issues pertaining to the accused's health.
We welcomed last Saturday evening the arrest, that's on 21 January, the arrest of Radovan Stanković in Bosnia, in Foča. The apprehension of Stanković is significant for the victims of the grave crimes he has been convicted for, and we hope that this arrest reflects an increased commitment of the authorities of Bosnia and Herzegovina to support the process of bringing to justice those responsible for the grave crimes committed on their territory in the early 1990s. The background: Stanković was a former member of the Serb paramilitary forces. He was indicted by the ICTY for crimes against humanity, war crimes, and rape committed in Foča. He was transferred to Bosnia in September 2005, pursuant to Rule 11 bis of the Rules of Procedure and Evidence, and he was sentenced to 20 years by the state court in Bosnia. But he escaped in May 2007. He was hiding for over 4 years, and I think it's also important to recall that our office has repeatedly called for his arrest. In the last report to the Security Council, we had emphasized the importance of apprehending Stanković, which remained a critical challenge for Bosnia and other states in the former Yugoslavia. That's it from our side.
Thank you. Questions?
I have a question about Vojislav Šešelj. His party has repeatedly claimed that Šešelj has been given wrong medicine in the detention unit, and furthermore that this was confirmed by the doctors in the outside hospital. Can you comment on this?
To a certain extent. What I can say is that there have been a number of inaccurate statements in the media over the past week or so regarding the development with Vojislav Šešelj's health. First of all, I would like to repeat something that I've been saying over the past few days, and that is that Šešelj's transfer to a hospital outside of the Scheveningen complex was not an emergency situation, but was a decision made by the Registry as a precautionary measure. The fact that he was returned on both occasions to the UNT within a couple of hours of going to the civilian hospital indicates that his health situation was not concern for the examining doctors, and they concluded that he did not require hospitalization. Also, as stated previously, it is the tribunal's obligation to respect fundamental human rights of every accused, and this includes the privacy of their health details. And Sredoje, as you know, continues refusing to allow the tribunal and the registry access to the details of his medical treatment. However, the information that we do have available about the treatment he has been receiving points to the fact that the statements made in Belgrade about the treatment he's been receiving are absolutely inaccurate.
Did the registry decide on Sredoje's request to be visited by Serbian doctors from Serbia, specialists?
It has. The registrar last night informed the accused that the team of specialists that he requested visit him will be able to do so in accordance with Rule 31. And the procedures are now underway, and it is an obligation of the accused, let me underline that, to arrange the details of and the specifics of the visit. But the visit has been approved, and the doctors of the choice of the accused have been allowed to visit the accused.
Could you confirm that one of them is a gynecologist by profession?
I wouldn't be able to disclose the names of the doctors that will be visiting the accused. However, what I can confirm is that all 4 names submitted by the accused in his requests have been approved by the registry. And I think also at this stage it will be important to highlight or underline the specifics of Rule 31, which allows such visits for any accused. And again, let me also address the issue of the alleged delays in the approval of this visit. It is inaccurate that there have been any delays. The rules specify that it is the accused alone that can request for specialists of his choice to examine him in the detention unit. I can say that the registry did receive a letter from an external party requesting for such a visit to be approved. This request was forwarded to the accused immediately, and following his confirmation that this is something that he wants, the visit was approved within a day or 2. So there have been no delays. But also I would like to highlight that the medical visits in accordance with Rule 31 can involve only certain types of activities by those visiting specialists. And this can involve, as I can refer to it here, the consultation with the detainee, non-invasive physical examination, for example, measuring blood pressure or listening to heart and lungs, etc., viewing the contents of the detainee's medical file, if the detainee gives his consent, and providing a medical opinion to the detainee and to the medical officer of the detention unit. So these are the only specific activities that can be undertaken by the visiting specialists. No questions?
I have a question, but it's regarding Karadžić's case. I would like to know if you have an answer about Colonel Ruiten's note. If he gave you an answer about the letter from the judge asking for his notebooks.
I would have to check if such correspondence has been received, and if so, if it has been received on public record. So I'll have to get back to you on that.
Okay.
Okay, thanks.